Good afternoon and welcome to today's webinar from BMA Law. BMA Law is an independent law firm established by the BMA, offering expert, cost-effective legal advice. Unlike other law firms, we operate on a not-for-profit basis, reinvesting any surpluses back into services for doctors. So this webinar today is relating to CQC inspections and enforcement. My name is Errol Archer. I'm a consultant solicitor advocate with BMA Law. I'm a regulatory and healthcare lawyer, and I've been so for nearly 30 years in both private practice and in-house working with regulators and with central government. So this session today is split into 6 parts. We're going to talk about CQC and GP practices in particular. Then I'm going to give you an overview of the statutory framework that governs CQC's operations. Then talk about their inspection framework, the single assessment framework, and current proposals to improve that framework. Then provide a few hints and tips about how best to deal with an inspection on the day of the inspection. Then look at the factual accuracy response process, which is often underutilised, particularly by general practice. And then talk about some of CQC's enforcement powers. There should be some time at the end of this session. We've got an hour today in total. The presentation will probably run to about 50 minutes. I'm hoping there'll be about 10 minutes at the end for Q&As. Any Q&As that we don't have time to cover, I'll be able to respond to during the course of next week following the session. I'll be able to respond to people directly if you're able to email questions in. So looking at the first part of the webinar, we can refer to CQC's annual State of Health Care and Adult Social Care report, which was published in October. And I just wanted to highlight a couple of findings from this report, the key findings. One is the increase in demand and the respectives. So the second one is the access to GP services. So we can see that increase in demand. So over 700,000 more patients were registered with GPs on average in the last year monitored compared with 23-24. This has resulted, of course, in bigger GP list sizes, and the number of appointments recorded in GP systems has risen by nearly 10% in the last 2 years. At the same time, following a survey, the 2025 GP survey that was carried out, that found that just over 50% of those surveyed say that it's easy to contact GP services, and just under 30% say that it's either difficult or very difficult. So these statistics reflect the continued growth on the demand side, and it highlights the continued need to facilitate, where possible, easier access to GP services. It's interesting to note that there's been an increase over that time of patients contacting and trying to gain access to GP services via online methods, either through GP's own websites, and that's up 3.1 percentage points from the previous year, or via the NHS app, and that's up by 2.2 percentage points from the previous year. So the focus of today's presentation is going to be towards GP services, and what we can see here is the findings of the overall ratings for the 488 GP services which CQC has inspected under the single assessment framework, under the new framework, since it was introduced and over the previous year. Additionally, there were 5,638 GP services with existing ratings from the previous inspection framework. We can see that of the overall ratings, 84% of services inspected were rated good, 13% were rated requires improvement, 2% outstanding, and 1% inadequate. We can see there's been a slight drop in the number of those rated good from the previous year. Previous year's figures are in brackets, and a slight increase in the numbers rated requires improvement. So how do GP practices compare to other service sectors? We can see that the percentage of services with a good rating in each of these categories, and GPs were rated good. 84% of GP services were rated good. 67% of adult social care services, so care homes, domiciliary care, and so on, were rated 67%. 67% were rated good. 65% of NHS and independent mental health services were rated good, and 52% in NHS acute. So we can see that this sector, the general practice sector, compares very well to other services in health and social care. So looking at the highest percent, the ratings that GP services achieved in relation to good in each of the 5 categories of inspection. So in safe, effective, caring, responsive, and well-led, what this slide shows is the percentage of those services that were rated good in each of those 5 areas, with last year's figures in brackets. So we can see that the last year, the caring category, there was the highest number of services were rated good in that category. This year, the highest number of services rated good were in effective. And of note, we can see that there's been a drop, a significant drop, I would say, in the number of services rated good in safe and well-led from the low 90s to the mid 70s. What that should prompt services to do is, if you have an inspection coming and on an ongoing basis, key areas of safe and well-led are ones that should really be focused on in terms of your preparation. So, coming on to the second part of the webinar, this is to provide you with an overview of CQC's statutory powers. CQC is a creature of statute. It was created by the Health and Social Care Act 2008. Therefore, importantly, the powers that it has as a regulator are only those powers as are specified in the Act, and there are no powers from elsewhere that it can draw on. As a statutory body, it is subject to challenge by way of judicial review as regards how it exercises those powers. There you can see from section 2 the key functions of CQC as a regulator, functions of registration, review and investigation, and also functions in relation to monitoring services under the Mental Health Act of 1983. But importantly, because CQC is a statutory body, it must act legally and in accordance with public law. So in its decision making, whether that's in relation to whether an applicant should be registered, whether it's in relation to decisions around inspection and enforcement, they've got to show and be able to demonstrate that they've acted reasonably, rationally, that any enforcement action is proportionate, and also that they have followed the correct and proper procedure in their decision-making processes. And this in particular applies of relevance to providers in this sector and others, is as regards how they exercise and make their decisions as regards inspections. So the inspection ratings that CQC allocates to providers must be based on the evidence obtained by inspectors. the starting point for assessing ultimately whether an inspection and the inspection report and ratings meet that public law standard is to consider the wording of the final draft report as published by CQC. So where the text of that report, so for example in the safe category contains far more positives than negatives, and yet is still rated requires improvement or inadequate, that raises questions around the quality of that decision making and of those judgments, and indeed whether those judgments are stand up to the public law standard of being reasonable and rational. And one notable case that springs to mind was a service provider which had been rated inadequate overall at one inspection. They were rated inadequate in the safe and well-led categories and requires improvement in the other three categories. So they were overall rated inadequate, and they moved into special measures, CQC special measures. This was followed by CQC issuing a notice of proposal to cancel registration, followed by a notice of decision to cancel registration. In response to this, the service did all the right things. They started to implement improvements where needed. They engaged the support of external healthcare consultants to assist them in doing this. And at the very next inspection, approximately 6 months later, the inspection returned ratings of requires improvement in each of the 5 categories. So this was good news. It meant that the service would come out of special measures, and it meant that the cancellation procedures would come to an end. However, the issue here was that when the final report was published, on reading the report, it was consistently positive in all categories. There were a very small number of minor issues that were raised in the report, but reading the report, it was glowing with praise. And our view was that it was irrational and unreasonable to allocate ratings of requires improvement where the content of the report and the findings that had been made were all positive, or mainly all positive. So what we then did was consider whether there were grounds to challenge CQC by way of judicial review. Another important factor here was that the CQC inspectors of this service had mentioned to the staff that they were unable to improve the ratings overall of a service from requires improvement, from inadequate at one inspection straight to good at the subsequent inspection. And they were implying that there was a policy that CQC had to this effect. So we looked to see if there was a policy. We tried to find any evidence of a policy. We couldn't. Therefore, we issued a letter before claim to CQC, threatening them with judicial review in the High Court unless they reran and reconsidered the rating process. So the outcome of this was that within 2 weeks, CQC's legal team had responded. They had worked with the inspectors to rerun the ratings process, and this service was as a consequence rated good in each of those 5 categories and rated good overall. What this shows is that where the evidence is there, where the evidence is reflective of a good service, CQC as a public body acting rationally and reasonably must rate the service as good, and that's no more or no less than we would expect. But it shows the effectiveness of the judicial review challenge process in holding the regulator to account where you feel things have gone wrong in terms of their processes. And the judicial review challenge process allows for a letter before claim to go into CQC's legal team, and the procedure requires them to respond within 14 days. So it can be a fast and effective way to resolve an issue and to ensure that your service is rated appropriately to reflect your level of compliance. So the focus today is generally going to be on inspection, on CQC's powers of inspection and what that means for practices. But monitoring is an integral part of CQC's functions. CQC's monitoring of services informs them as to who to inspect, which services to inspect, when to inspect, and whether an inspection is urgent. And it also provides them with good quality information around trends at that particular service. Have there been an increasing trend of notifications, statutory notifications of a particular type? Have there been reports to them from patients or others of any particular issues? And they can then prepare their inspections in response to those. There's a role that's quite a strong role that CQC has in relation to supporting improvement of services, and this was reflected in comments in the 2025-2026 business plan that CQC published, where they stated that we regulate health and adult social care, we work together with the public systems and providers of care to improve the quality of care. They go on again to say that to stress their role in working to improve the quality and equity of care. And in addition to this, the former Chief Executive, Sir Julian Hartley, when he was commenting on the 10-year health plan back in July, stated that they're already developing new, clearer, simpler assessment approaches, making sure our experienced teams of inspectors will be able to conduct more inspections and share feedback on the findings more quickly so that we can support providers to make faster improvements. So there's certainly a greater emphasis on that improvement agency role. It's not an improvement agency, but there's certainly a greater emphasis on that. And that's shown through in recent years as well. So judicial review is the way that the individuals and organisations can hold the executive to account, i.e. government departments and public bodies. It subjects those departments to the rule of law, and it's been used over the decades to challenge decisions ranging from those affecting human rights through to our country's relationship with the EU, through to complex medical and ethical decisions. It's a bedrock of the legal system as part of our constitution, as a key part of the three arms of state, the executive, parliament and the judiciary, and it's the way that individuals can use the judiciary to hold the executive to account. From a legal perspective, we must be able to show that there's been an error in law, or that the regulator has acted unreasonably or irrationally, or alternatively that it hasn't followed the correct procedure. So, for example, a failure to disclose documents to enable representations to be made against an enforcement notice is one example there. So that just gives you an overview of the framework, of the statutory framework. So we'll come on now to the single assessment framework. So you may or may not be aware that CQC introduced a new framework for assessment from January 2024 to replace its previous model of key lines of inquiries, with CLOEs as they were called. However, the implementation has not gone without difficulties, and government and the regulator itself has accepted that the implementation of the new framework has not met the regulator's objectives. And indeed, it's issued a consultation in October, 16th of October, it launched a consultation called Better Regulation, Better Care, with a view to improving the way the framework for inspection. And responses to the consultation can be made up to 5 p.m. on the 11th of December. And in its consultation, it is proposing the following changes. Firstly, a reintroduction of the ratings characteristics that were used previously. They're going to be referring to these as, so they're going to, that replacement, they won't be bringing in the old ratings characteristics of themselves, but they will be introducing rating characteristics, an improved version of ratings characteristics. They will be replacing the quality statements that are currently being used to support their inspections with what will be referred to as assessment questions. And these will be very similar to the previous key lines of inquiries. They're proposing a return to sector-specific inspection frameworks, so moving away from this single assessment framework that they apply to every sector. And they're going to be looking to rating judgments at key question level rather than focusing on the scoring of the underlying statements. They're looking to encourage a greater emphasis on the use of professional judgment of inspectors in reports. This, of course, depends in a large part on the quality and the experience of CQC's inspectors. And we know over recent years, CQC has lost many senior inspectors, many inspectors with years of experience, and it will certainly be a challenge for them to ensure that the experience, the knowledge of their inspectors is such that in exercising professional judgment during inspections, those judgments are going to be reliable. So we'll hope to provide a future webinar on those detailed changes during the course of next year when they come in. But for the time being, we do have the single assessment framework. There's an ongoing assessment of risk through that, and there's a greater emphasis on remote assessment and monitoring and inspection of services. As I mentioned, the previous key lines of inquiries have gone. They're going to come back in, but for the time being, they're gone. And they've been replaced with 34 topic areas. The rating system remains the same: outstanding, good, requires improvement, inadequate. And currently, it's underpinned by numerical scores, which is a feature of the single assessment framework. Those 34 topic areas are broken down into the 5 categories of inspection as follows. So, and within each of those categories, below each of those topic areas, there are a number of quality statements which CQC inspectors use in gathering evidence during inspections. And there are 6 sources of evidence that they can draw on: people's experiences, so they can speak with patient feedback, feedback from staff, feedback from partners such as local authorities, commissioners, and so on, observations of care, and processes, so looking at your policies and processes, and also at outcomes. So scoring has been a key feature of the single assessment framework, and one might think that having scores allocated below the judgments would assist in more accurate and fair ratings. But one of the key things that's come out from CQC's own investigations into this framework is that the inspectors have found it overcomplicated. But for the time being, these scores are still being used, and the scores are aggregated for each of the quality statements, and percentages allocated out of the total score possible. And a percentage over 87% would result in a rating of outstanding, 63% to 87% good, 39% to 62% requires improvement, and 25% to 38% inadequate. And having these percentage ranges, the scores, was one of the aims of this, was to be able to demonstrate how near the top of a particular rating band or near the bottom a service stood. But the point is, following Professor Sir Mike Richards' review over a year ago, those scores are no longer being given for each of the underlying evidence sources, and CQC is certainly moving away from that type of scoring. But if you are inspected, you've got an inspection imminent or coming up in the coming months, this is the framework that will apply. So, following the reports of Penny Dash and Professor Sir Mike Richards last year, as well as analysis more recently by the Care Provider Alliance, in addition to the proposed reintroduction of parts of the previous inspection approach, the new consultation, Better Regulation, Better Care, is focusing on improving 4 areas of concern, in particular for CQC. They're looking to ensure that CQC is able to publish reports of assessments that they have completed. They're looking to increase the number of assessments they can complete in each month. So once the consultation has been completed, once the new policy decisions have been made and the changes implemented next year, this should result in a greater number of assessments being completed each month. One of the key aims is for CQC to clear their registration backlog. This is more of an issue in some other sectors than in the GP sector, primary care sector. And they're looking to make sure that they can act promptly on information of concern and statutory notifications as well. So there has been a changing role of CQC inspections with the single assessment framework. So they move away from conducting only traditional on-site inspections, so a greater focus on monitoring services and maintaining an up-to-date ongoing view of quality and risk, and a focus of ensuring that on-site inspections are targeted on those services which are perceived as presenting the highest level of risk. So this is just a long list of various things that have happened over the last year. There's been quite a number of developments and changes with CQC in relation to its inspection framework and the way it regulates. The most recent developments have been the allocation of the 4 chief inspectors of care. These were allocated, that's the appointment of these people between July and October. So we now have 4 chief inspectors of care at CQC. And most recently has been the consultation, Better Regulation, Better Care, which you may wish to respond to, responses by the 11th of December into CQC. Via their website. And there's going to be a return overall to the policy approach of the previous framework, a reintroduction of the rating characteristics, sector-specific frameworks, more statements of professional judgment in reports, and other changes. And the expectation is that those changes will feed through into practice during the course of next year. As regards the timing of inspections, the interval between inspections, we know the previous framework before the single assessment framework, the frequency of inspections was based on your rating. However, the single assessment framework has moved more to planned assessments and responsive assessments based on their assessment of risk in your service. Planned assessments, all GP assessments are announced when they are planned to minimise disruption, both to patients and to staff in running the service, and then usually announced with 1 to 2 weeks' notice. Responsive inspections, those in response, for example, to a whistleblower or to patient complaints or safeguarding alerts, can happen at any time. There's likely to be a return to a more predictable frequency of inspection following the proposed consultation changes. So That moves us away from the single assessment framework to looking at inspection. So if any of you have an inspection imminently, if you're expecting one in the coming months, then apart from responding to the pre-inspection requests that you will receive for specific information, we know that CQC will be focusing on gathering evidence from, in particular, from patients. So patient feedback is a key source of information for CQC inspectors. They will be speaking to staff, and they will be seeking evidence, of course, from your computer systems. They'll need access to your software and other documentary evidence as well. One of the key things that I've observed from those practices that appear to do very well at inspections is the nurturing of a mutual sense of respect between staff and CQC's inspectors, with a sort of sense that you are all working together with the same objective of providing the highest level of care. And certainly when inspections work well and there's good communication, that really works. So that's certainly an atmosphere in which ideally you would want the inspection to take place, involving staff as fully as possible in the inspection process. So some practices will have staff sessions, preparing them for inspection in terms of letting them know what's likely to happen, that they may be asked questions on particular topics within their area or more generally within the practice, what the consequences of the inspection might be. But the more involved staff staff are at all levels, the better place the practice is going to be to respond to those questions from inspectors. And also those practices that celebrate success when they do have good inspections is only going to serve to maintain those standards and that positive culture. So on the day of inspection, first impression, of course, do count. The last thing you want is the inspections coming into what appears to be an office, a chaotic office or chaotic work environment. So it's always worth attending to those basic necessities. At the start of the visit, start of the inspection, there will be an initial meeting. The inspectors will usually meet with your registered manager and all the partners. There may be some other senior members of staff who will sit in. And so the CQC inspectors will cover the scope and purpose of that particular inspection. Are there any particular matters that they want to focus on? They'll explain their plan for the day, whether they're looking to speak to particular members of staff, who they're thinking of speaking to. They'll need access to records, which records they will need access to, and they'll also let you know when they're likely to have a mid-inspection update with you during the course of the day. It's important for them to discuss with you how they will raise and escalate any concerns, particularly urgent concerns, that they come across during the inspection. This will usually be with the registered manager. It need not be. And of course, some inspections, the registered manager will not be there. They'll be on annual leave. So you need to think about who would be that key point of contact for the inspectors. And of course, in many practices, the senior partner is also the registered manager. So that's going to be quite key to ensure that that contact is there and ready to deal with any of those issues as they arise. CQC will also explain how they're going to communicate their findings following the inspection. So you usually have the opportunity, sometimes you'll have more time or sometimes less time, to give a provider presentation. Now, when I say presentation, this may just be a brief discussion in one of the partners' offices, or it may be something slightly more formal, where you've put something on a laptop, you open the laptop and you can explain some matters of progress, changes in the practice, improvements, and so on. But this is a golden opportunity really to take the lead insofar as you can, to inspire confidence and to establish credibility with the inspectors, to show that you're on top of things in the practice, to share your own view of the practice's performance. If there are issues of concern, areas you're working on improving, let the inspectors know you're well aware of that and you're dealing with it. You may want to share examples of outstanding practice, of practice that meets an outstanding level of performance. And it's always useful to let the CQC inspectors know that you understand how they inspect, the categories of inspection, the 6 population groups insofar as they're relevant to your particular practice. And of course, be confident, you will be prepared to explain to them where your practice stands. You may have a little handout, and the key thing here is really to communicate knowledge, confidence, and a willingness to cooperate and work with the inspectors at this really crucial first meeting. And of course, normal housekeeping, the inspectors will ideally want somewhere clean and tidy where they can sit and do their work. They'll often be sat in front of one of the computers in any case, but they need to know where the toilets are, where the kitchen is, if they need a cup of coffee. All those sorts of day-to-day things are worth just thinking about to make the inspection as smooth and comfortable as possible. So there will be feedback during the course of the day, urgent feedback. If there are any key urgent issues or issues that go to risk, these should be raised with you immediately. And CQC will raise these, and they'll be looking for a response from you in terms of how you are going to respond to that and resolve that issue of concern that they've raised. If they do give any feedback of that nature, you want to let them know clearly that who on the day is going to be dealing with that, how you intend to deal with it, and ideally you'll be looking to respond to them before the end of that day of inspection. There'll be a halfway review, usually just after lunchtime, where CQC's inspectors will be planning and coordinating what they're going to be focusing on that afternoon, and they'll be sharing that with you. And this may also prompt further feedback to you, and also it's an opportunity for you to clarify any issues of concern, and also to flag with the inspectors any particular points or issues that you feel they may not be aware of. If they've been looking at certain areas of inspection and they haven't looked at particular evidence is available in the practice, that's a good time to flag that up with them. There'll be formal feedback at the end of the inspection, where CQC's inspectors should sum up their findings, any immediate actions. And again, it's another golden opportunity for you to ensure that you're clear as to where you stand as regards this inspection. As with many things, it's always good to try to finish on a high and on a positive note. Clarify, ask any questions that you have about concerns that CQC's inspectors have raised. Ensure that you're able to provide them with further evidence if you feel they haven't seen all the evidence that is relevant. And of course, your last impression, ideally want it to be a very positive one. And the final thing is to thank the inspectors. You may not feel like doing that after a grueling day of inspection, but when the inspection works well, it's a really valuable opportunity, really valuable learning opportunity for the practice to drive improvements. So we're just coming on now to the factual accuracy process. So following your inspection, you will receive a draft inspection report, usually within 3 to 6 weeks after the inspection. And often in the busy day-to-day of general practice, it'll obviously be read and looked over in detail by the partners and by the practice manager, but it will not always be responded to in detail via the factual accuracy response process. And this is the only opportunity that you have to substantially challenge the evidence, challenge the judgments, to clarify any issues of concern. And the best approach to the factual accuracy response process once you get the draft inspection report is to review it objectively and in a forensic manner, think about and focus on the evidence. So paragraph by paragraph, as you're going through the inspection report, what evidence is available to you in relation to that particular point? Is there evidence? Is the evidence that has been referred to, the findings that they're making, do they appear to be accurate? Have they identified all of the relevant evidence? Is it clear that, or is it apparent that there's some evidence that is relevant that they haven't looked at? In which case you need to flag that up with them and provide that to them. It's important just to remember that the factual accuracy process is not the place for complaints. If there has been a concern over the conduct, for example, of an inspector, then this should properly be the subject of a formal complaint through CQC. Rather than through the factual accuracy process itself. Only 10 working days to respond in detail. So it's important to consider what resources you have available. Many practices will ask their registered manager, who will take the lead in formulating a response and coordinating information from the partners. It is important to consider whether you need external help for this, whether it's by way of an external healthcare consultant or a lawyer. It's something that I certainly work with many practices on to support them and to provide an extra resource in terms of dealing with this rather sort of lengthy and time-consuming task to allow staff to focus on their day jobs. So yes, so I think that's the key thing is once your response has been submitted, your factual accuracy response, CQC will consider it and they will respond back to you with an analysis of your responses, whether they accept them or not, whether they don't accept them, why they don't accept them, and whether, in light of your factual accuracy response, any of those individual ratings will be changed, and therefore, of course, whether the overall rating of the service will be changed. If any practices have concerns over a draft report that they have received or need support, please use the BMA Law CQC helpline. We're available to help and support if needed. So this is just breaks down a little bit more detail, the best and most effective approach to dealing with the factual accuracy process, and just breaks it down into stages. Please bear in mind that when you're preparing your factual accuracy response, there is a word limit of approximately 500 words, between about 400 to 500 words. It's a 2,000 character limit, so about up to 500 words for your response in respect of each of the statements that you're challenging. So it's really crucial to ensure that your response is concise, and the more concise you want your response to be, the more time you'll need to make it concise. And my strong advice would be to put aside at least one full day to upload your responses. So ideally, you would prepare your responses on a separate Word document, for example, in relation to each of those statements that you have got comments for, and you'll have your evidence in relation to each of those items already, so that when you're ready to upload onto the portal, you can simply cut and paste into the relevant parts of the portal against each statement, and you can upload the evidence you've already got ready in relation to each part. So there's a little bit of a sort of project management approach to doing this. It's very easy. I know of many providers in different sectors who have had an absolutely nightmarish day trying to upload or trying to complete the factual accuracy response on the portal, and from experience, drafting it out separately and cutting and pasting it in and putting aside at least a day is a sort of prudent thing to do. And if you remain dissatisfied with CQC's response once they've considered your factual accuracy response, there's a ratings review process that's available to you, and this focuses on whether CQC have correctly followed their processes in relation to the factual accuracy process and inspection. So if, for example, a very obvious thing here would be if they hadn't given you an opportunity to put in a factual accuracy response, or if they if they had only given you 5 days rather than 10 days. But it's any aspect of their procedure. If they haven't followed it, then that's something that you're able to challenge through the ratings review request process. So coming on to the final part of this webinar, and this is, we're looking here particularly at enforcement. So where things have gone a little bit wrong and where there have been breaches of regulations, CQC has a range of powers that it can use to take enforcement action with a view, as we were discussing earlier, to encouraging practices to improve. They've got their civil powers, and they've got powers on the criminal side. So their civil powers are their notices of proposal they can issue to cancel or to suspend, notices of decision. They can issue warning notices as well. And ultimately, where there is civil enforcement action, that will end up in the first tier tribunal, or alternatively in the High Court if a challenge was made. On the criminal side, where a fixed penalty notice is issued, for example, or where a prosecution is taken in the magistrate's court for failure to make statutory notifications or failure to comply with other aspects of regulation, this would end up in the magistrate's court. And CQC have indicated that their aim, of course, and it ought to be, is to take proportionate action to encourage prompt improvement. So where CQC has usually where there's been an inadequate rated inspection, there have been breaches of regulation, and CQC have concerns over patient safety, they will issue a notice of proposal to either suspend a practice or to cancel the registration of a service. And this is the first of a two-step process. The next step being the issuance of a notice of decision. But at the notice of proposal stage, this is CQC saying that they're proposing to cancel your registration or they're proposing to suspend. And you have an opportunity to submit written representations to that notice of proposal. You have 28 days to do that. And again, it's crucial to look at the notice of proposal paragraph by paragraph and with a forensic eye and a forensic eye for the detail. For CQC to issue a notice of proposal to cancel or suspend, this tells you that they're extremely serious. They have very serious concerns, and they will have had their legal team ensure that the notice of proposal, the notice of decision has been very carefully drafted, that there's evidence to support. So from your perspective, you need to have a similar approach, a similar detailed approach, if you want to have any chance of persuading CQC that they need not continue with their enforcement action. Evidence is absolutely key in responding to enforcement action, and if you put in representations simply explaining your view of things without any evidence, you would not be able to persuade them to curtail their enforcement action. And what you want to be doing is to be cross-referencing any statement that you disagree with, any comment in relation to compliance that you disagree with, or where you feel that improvements have been implemented that mean that you are now compliant. You need to provide evidence to back that up and to demonstrate that. Notices of proposal to cancel can run from 4 to 5 sides of A4 to 20 to 25 sides of A4, depending on the number of issues that have been raised. But it is essential to put in a detailed response if you do want to have a realistic prospect of persuading CQC that the service, that either they made mistakes in their inspection or that the service is now compliant. Where CQC are not persuaded by your representations, they will issue a notice of decision. So they've decided then that they're going to cancel your registration or to suspend you from practice. At this stage, you'll have, again, 28 days to respond, but you'll be responding by way of an appeal to the first tier tribunal in the Care Standards Division of the first tier tribunal. You need a similar approach, and a notice of decision usually contains an explanation as to why CQC are still not satisfied by your representations and why they still feel that there are breaches of regulations or failings in relation to compliance falling short of a breach of regulation. So you need to respond to each of those outstanding matters with evidence, and that will go to the tribunal with a covering a form. There's a particular form you've got to complete, and you should also provide supporting evidence, of course. It's important to appreciate that once your appeal goes in, it will be approximately 5 to 7 months before the hearing at the tribunal would take place to determine whether cancellation, this is for cancellation in particular, whether cancellation should take place. And also very importantly is that the, sorry, let me just go back, the slides moved forward, is that the tribunal itself will consider your compliance as of the date of the hearing itself, 6 or 7 months hence. So what this means is that there is time for you to build up a body of evidence to demonstrate that you are compliant. History of compliance is relevant for the tribunal, but more relevance is whether you're compliant at the date of the hearing. So there is an opportunity for you to turn things around at that stage. And it's important to think tactically and strategically in any litigation, and this is a form of litigation, it's enforcement litigation. And ideally what you'd want to be doing is putting in as strong a set of representations or appeal reasons as soon as possible to persuade CQC that you're going in the right direction, in the direction of compliance. And you'd want to be inviting and seeking CQC's legal team, if you're in the appeal stage, to agree a stay of proceedings. So you would put the appeal in and they would see the strength of your argument, the evidence that you've got to show that improvements have been made, etc. And you'd invite CQC to agree that the appeal proceedings are put on hold for 2 or 3 months so that you can continue to implement those proceedings and so that they can come back in to inspect and hopefully agree with that and therefore bring the tribunal appeal to an end by way of a consent order. So it's really important to think strategically at that stage. But ultimately, evidence is king with these sorts of matters of litigation, and you must build up that body of evidence to demonstrate compliance. The CQC also has powers to take urgent cancellation action and to take urgent suspension action. It will take this type of action where they view there to be serious and immediate risks to a person's health, life, health, or well-being. So just some actions that could be useful to take at the moment is, if you are interested to have a look at CQC's consultation, it's on their website. Consultation responses need to be in by the 11th of December. So there are a couple of weeks to do that if you wanted to do so. Consider commissioning an expert CQC healthcare consultant if you are experiencing regulatory difficulties. Many practices are able to turn things around on their own, some struggle. And there are resources out there, of course, that your LMC will be able to provide support, but there are some extremely experienced and effective healthcare consultants who you can call on. Yes, there will be a cost attached to that, but if you can find the right person to assist, that can be crucial in supporting the practice at that important time. They will, of course, step away once you're on the right track back to compliance. And the other point that I would just flag up is that folder with examples or case studies of where your practice has done an amazing job, which will happen week in, week out, month in, month out. And in the hustle and bustle of day-to-day work and pressures, often is forgotten about by the time the inspection comes. But if there can be somebody allocated to maybe gather those good case studies and keep them in a particular folder, that can be gold dust when you come to an inspection. It can be really, really helpful. So thank you all for joining and for listening through to the end. Those are my contact details. Please feel free to contact me if you have any issues at any time. Very, very happy to speak to any members. Remember, we also have a helpline, CQC helpline. Please feel free to call that as well. We're always happy to assist. Now, I'm trying to see what questions we have in the inbox. Just bear with me a moment. So what we will be doing, we'll be gathering any comments that have come in and questions, and we'll be able to respond to these individually. I'm having problems at the moment reading those questions that have come in. Just scrolling down. Okay, I'm just scrolling through. Will this session be, so this is more housekeeping, be emailed afterwards? Yes, it will. I understand that attendees, people who have signed up, will be forwarded a copy and a link to this session, so you'll be able to listen to it or to watch it afterwards. Slides will be made available. They'll be available online, and they'll be emailed out to you. It has been recorded. There will also be subtitles available for those who need them. So I've got a question here. Is it deemed reasonable if, due to their IT system failures, inspection reports ratings have not been provided to practices for 1 year? Well, that is absolutely not reasonable. No doubt you will have been communicating on numerous times with them, but I would certainly say with something like that, it must be escalated. Whether you could seek the support of your LMC to assist in escalating that, or certainly we'd be happy to assist you in getting a letter, a more formal letter off to CQC, but you should not be waiting anywhere near 1 year for the outcome of an inspection report. And I'm sure CQC would certainly agree with that. One moment. Sorry, is this decision published? Can it be shared? I'm not sure which decision that was relating to. That might be relating to that case study I was talking about in relation to the use of judicial review. That wasn't a court decision because CQC responded after the 2-week periods. There was no need for us to go to the High Court. So that isn't published. I've got numerous other examples. If anybody wants to discuss any of those issues with me further, please feel free to contact me to do so. Will they also improve the timeline for registration? Well, this is a huge issue for CQC, and it's one of the key factors that they have highlighted as one of their objectives and something they're looking at during their consultation. So the expectation, the hope is yes, and CQC has certainly indicated it's one of their priorities. Yes, somebody's commenting they think that there's a clear need to simplify the process for registration of very small practices. Anything being considered? There's nothing that I'm aware of. However, any consideration by the regulator on the registration side or inspection side should be proportionate. However, the same regulations will apply regardless of the size of your practice. So I'm doubtful that there would necessarily be much scope to simplify the process, but certainly if CQC is considering doing that, there will be information potentially on their website, but it's not something that I've come across. And I do know, unfortunately, that they are behind in their registration process. So I think the answer, as far as I know, is no. There's nothing in the pipeline at the moment for that. But overall, CQC are focusing on improving their registration process and dealing with the backlog. I know we're just hitting 2 p.m. and I know many of you will have to go to attend to other important matters, but I will just continue for a few more minutes for those who can remain. So I would like to assist you with these questions if I can while we're online. Is that yes, indeed. So is there a list of the 34 topic areas on the internet? Yes, there is. They're listed on CQC's website, and you should relatively easily be able to find them on there. If you simply search for that, you should be able to find those. If you have any issues, please drop me a line and I could send you a link as to where they are contained. Yes, and so important question here. Does an appeal against a CQC inspection, so a challenge to inspection, involve a cost to the practice? You mentioned what you said was judicial review of a requires improvement rating despite positive narrative. That sounds expensive. So yes, engaging BMA law does come at a cost, but as I've explained, we're a not-for-profit firm, so any funds are reinvested to support doctors. The costs will depend on the time that we would have to spend in relation to that particular matter, and as all law firms should be, we're very upfront with the costings, and we also try to provide a fixed fee quote for any work that we do as well. So there is a cost. It's not possible for me to give you a range, but there is a cost. If you have a particular issue of concern or you think that you need the support, please contact me. I'd be very happy to have an initial look over any documentation and give you a guideline as to what the cost would be if you wanted to engage our services. And I'm always happy to spend some time, 15, 20 minutes, having a telephone call with members, talking through the issues, free of charge, before you have to commit or before you, to assist you in deciding whether you wanted to engage our services formally. There are more questions. I think maybe a few more questions we can deal with. Yes, significant variance with inspections across London historically, some as long as last was 8 years ago. Wow, with others receiving them almost every 2 years. Sadly, this has been quite a big issue over the years, and historically, I would agree with the person who posted this issue, both with the interval of inspections and also with the experience of inspections in different parts of the country as well. One of the aims of the single assessment framework process was to enable CQC to more quickly to be able to update CQC ratings of practices and other providers. I'm not sure that has actually worked. I don't think that's fed through, but yes, it's an issue. The matter of consistency is something that all regulators struggle with simply because of the size and the number of practices and providers they need to register. If you feel that too many years have gone by since your last inspection, particularly if you were rated requires improvement and you're adamant that the service is good, then you must engage with the regulator, with your lead inspector, and keep engaging with them. It does theoretically get to a point where they are acting unreasonably if they don't come out to inspect, to re-inspect, to re-rate in the face of evidence that you've presented them with. So yes, there are things that you could potentially do, either yourself through formal requests to them, through formal complaints, or through our assistance as well. Yes, and there's a very interesting question here. Are we still allowed to ask an LMC representative to attend your CQC inspection? As far as I know, absolutely yes. There's no reason why any other professional should not be able to attend that inspection as well. If you're engaged in the services of an external healthcare consultant, there's no reason why they should be excluded from being present at the time of the inspection, to support the practice, to support people morally as well. So the CQC should have no objection to that. So there's some very other questions. I think I will bring it to an end now because we're getting to 5 past. I don't want to overrun too long. There are some. I'm just trying to see if I can squeeze. It's very hard to determine between these questions. But what I will do, where you've left responses, I will respond over the coming week or so. There are questions around details of CQC healthcare consultants, potential exposure to criminal liability as registered managers. I will respond to those. They're important questions, but I'm afraid we're probably getting out of time. Please feel free to contact me if you have any questions or use the helpline. And I hope this was useful. And thank you for attending. And I'll bring the session to an end now. Thank you.